explain to the community that they acquitted Trayvon Martin. So if in fact, though, let me slow down a minute here. If in fact O'Mara were to challenge an African-American juror, potential juror, then the state would call upon the court to ask O'Mara what his reasons is, and it has to be a race-neutral reason. If the court finds that it's pretextual or that it's not a race-neutral reason, the court can deny that strike and say, no, I'm not going to allow you to strike that juror.
So even using those 10 that you talked about that are so coveted like gold, can you use one of the 10, if you don't say it publicly or in the courtroom, can you look at some jurors and say, that's not who I want, and boom, they're gone, without a challenge?
You can under normal circumstances if the person that you're challenging is not a protected class and a minority class. If they are, then you're going to have to explain to, and let me go back just a second, when you exercise a peremptory challenge, you don't have to explain why. You can just say, I don't like the color of their hair or the fact that they don't have any hair. And if, however, you're challenging a minority, then if the state challenges a minority, the defense can say, hey, Judge, we want to hear what the reason is, and it has to be a race-neutral reason. And the court doesn't necessarily have to accept the explanation, and if they find that the explanation is in fact pretextual, then the court can say, not going to happen. You can't exercise your challenge and remove this juror.
Do you then lose that challenge, or because? No. So you still have it?
Yeah. I didn't mean to interrupt you, but no, you don't lose that challenge. You lose one of your 10 peremptory challenges. You lose the challenge because that juror is going to stay.
Yeah, like in the NFL, you know, if you throw the red flag, you lose a timeout if you're denied, right?
Yes.
So as we look at this, Deborah Nelson again, the judge in this case, George Zimmerman, Trayvon Martin. We've been waiting for quite a while for this day to come. Here it is, June 10th. Jury selection supposed to start at 9. There was the denial of the defense's again, attempt to delay the start of the hearing. That was denied, according to Kathy Bellich, who you can follow on Twitter. She is in the courtroom right now. You can follow us as well on our Twitter accounts, at Bill Schaefer PA, at G. Wormuth WFTV, and on our live blog here on WFTV.com. We'll get to some of your questions. We see those starting to stream in on our live blog. Plus, we're monitoring that as well. If one of our assistants who's back at the internet can answer any of your questions while we're talking, he will do that as well. So, again, downstairs, Deborah Nelson is the only one who can address those potential jurors who have been gathered on the first floor of the Seminole County Courthouse. She's the only one that can talk with them, but the defense and state will be listening in. And I want to go back for our people who have logged on. Before this all started, before Deborah Nelson came in at 8:59:28 this morning, Tracy Martin, Trayvon Martin's father, stood up in court, and he addressed the media who have are attending the trial. And I want folks to hear Tracy Martin, and this was interesting because I haven't seen this before something starts. Here's Tracy Martin. This is Trayvon Martin's father about 25 minutes ago.
We are relieved that the start of the trial is here with the jury selection as we seek justice for our son Trayvon, and we also seek a fair and impartial trial. We ask that the community continue to stay peaceful as we place our faith in the justice system, and we ask that the community do the same. We ask that our families and friends continue to pray for us, continue to keep us safe in God's arms. We ask that you continue to pray for Trayvon and our family. Thank you.
Tracy Martin, he is praying for God's arms to wrap around the family, keep them safe, and he also said he is hoping the community remains peaceful because this trial, not just the conclusion of this trial, Bill, but there will be moments in the trial, and there'll be at least 4 pastors from the Sanford community in there, will have moments of high emotion. Mark O'Mara will, no doubt, the defense attorney in this case, paint Trayvon Martin in maybe not the kindest of light in trying to protect his client from going to prison for the rest of his life.
That's O'Mara's job, and as you said, it's bound to happen. How broad of a brush he's allowed to use to paint is going to depend somewhat on how the state attempts to paint or portray Zimmerman, but you can bet there's going to be evidence that comes before this court and before this jury that's going to be stinging to the Martin family, as well as you certainly can expect that would happen. I just have to say I admire Natalie Jackson. I admire the Martins. They have done nothing but call for calm and peace, and that they act in a very responsible manner. All they wanted, that you and I were able to glean from Natalie Jackson during your Central Florida Spotlight interview, was we just wanted to make sure that the process took hold, because the process seemed not to be taking hold at the time George Zimmerman was not arrested, and they felt, the Martins and Natalie Jackson and others felt that, wait a minute, this defendant or this accused needs to be arrested, he needs to stand trial, and we need to have a jury decide whether or not he was justified in using the self-defense which resulted in the death of this young teenager.
And we can never lose sight of a 17-year-old's life is now over as a result of what happened on that February night about a year and a half ago. As we proceed in this, the way the case will play out, the state will present its side and run through its entire case, and then the defense will have its turn.
Yeah, the bottom line is the state always goes first, and the state you hear from last. Why is that? Because the state has the burden to prove the case beyond and to the exclusion of every reasonable doubt. As this trial unfolds, we'll talk about what's known as a little burden shifting here when the defense raises this issue of self-defense. But again, even when Mr. O'Mara raises this defense of self-defense, the state has the burden of proving the case, and if you will, proving beyond and to the exclusion of every reasonable doubt that Zimmerman was not proper, and it was not a defense to use his firearm and take Trayvon Martin's life.
We're still probably a couple of weeks away from even hearing the state, Bernie Daly Rionda, getting up before the jurors and before the gathered folks in the courtroom 5D, and even laying out his case. We don't know his tactic. We don't know really to any degree Zimmerman's side's tactic either. But what we do know right now is that Deborah Nelson, the judge in this case, is downstairs here at the Seminole County Courthouse, which is right behind us in Sanford, Florida, and she is talking with the right now gathered about 100 potential jurors. They have to get down to 6 jurors. Unlike the Casey Anthony case, they have to have 6, and she would like to have as many as 4 alternates, because she knows that, well, one of the worst things you could have is have this case roll along, not have enough alternates, somebody gets sick, for some reason they are kicked out of the jury pool for inappropriate conversations or whatever, so she wants to have 4 safety valves.
Yeah, we see that in these cases that are high profile or that are going to take a long period of time, and certainly in the context of trying cases, usually cases are tried within a week. It is unusual when you have a case go beyond a week, and certainly unusual to have a case go as predicted 6 weeks in this case. The longer the case goes, the greater the chance that something may happen that cause one of these 6 jurors not to be able to finish the case. And remember, Greg, there's no such thing as a verdict of 5, 4, 3, 2, or 1. You have to have 6. You don't have 6 for whatever reason, guess what? You're trying this thing all over again.
So that is still out there, and that's still a possibility with 6. Maybe a little easier to get 6 together than 12, which is what we had to get together on the Casey Anthony death penalty case.
Yeah, you know, and the reason we don't have 12 jurors, you're only entitled to 12 jurors if it is a capital death penalty case or a capital case, first-degree murder. You're charged with first-degree murder whether the state seeks death or not. You get a 12-person jury. If it's second-degree murder or any other, no, you only get a 6-person juror. The only exception to that, believe it or not, is a case called eminent domain. If the state or someone is trying to take your property, the state or the government, you're entitled to a 12-person jury, which is different than the federal system, by the way, Greg, because in the federal system, no matter what the charge is, you get a 12-person jury.
Okay, so again, as we look, the jury will be seating at some point in this jury box in the Seminole County Courthouse, 5D. You've been in there. We're taking a look at some video right now. Compare and contrast, because the Casey case, it became so widely known, you know, on the 23rd floor is where they tried that. This is on the 5th floor. You mentioned earlier a nice courtroom, but not nearly as big as that one at the Orange County Courthouse.
No, the Orange County anticipated, because when the Orange County Courthouse was built, we had trials of great magnitude, at least in the country, and trials of great duration. They call it the ceremonial courtroom because when lawyers are sworn in, or judges, or other ceremonies, they use that courtroom, fallen law enforcement officers to pay homage and things of that sort. When this courthouse was built, no, we couldn't look into the future, didn't have a crystal ball to see that we need at least one courtroom to accommodate all the media, the public's right to know, the defense, the prosecution, spectators, and all. But very nice courtroom, again, and more intimate, which the lawyers kind of like. You don't want to actually be in a big cavern trying to case.
How close in this case will Zimmerman's seat be to the jury? Lay out the courtroom for us.
Yeah, well, the prosecution always sits closest to the jury. I don't care whether it's state court, federal court, county court, circuit court. The state gets to sit closer to the jury. The state will be probably, oh my gosh, maybe 10 feet from the jury. Then Zimmerman will be, and the defense at the table just to the, facing the judge just to the left, and they'll probably be 15, 20 feet from the jury. And the judge is relatively close, and so is the witness to the defendant and the prosecution. And then the spectators are very, very close also, which is why so much there's a buffer zone between Zimmerman and the audience for security reasons. But again, it is a more intimate setting. I know we keep talking about a comparison to Casey Anthony, and the reason we do that is because there are so many now individuals and people that are familiar with the judicial process based upon their watching the Casey Anthony trial. And I think it's a fair comparison there to talk about, well, what you saw there, what you will see here, and what you won't see. By the way, I want to tell you something. You're going to see a fairly conservative opening statement, at least by the prosecution. The reason being is that